The DA tabled the motion in November last year. The Speaker of Parliament ruled the debate could not take place immediately. This led to opposition parties going to the Western Cape High Court. Judge Dennis Davis dismissed the application. Deputy Chief Justice Dikgang Moseneke read the majority decision today. He reiterated the Speaker does not hold the appropriate power to schedule the debate. But the court found that the National Assembly must hold the debate within a reasonable period of time. The court has given Parliament 6 months to amend its rules. The judges found Parliament's rules do not allow for timeous debate.
It is declared that Chapter 12 of the Rules of the National Assembly are inconsistent with Section 102, Sub 2 of the Constitution, to the extent that it does not provide for a political party represented in or a member of the National Assembly to enforce the right to exercise the power to have a motion of no confidence in the President scheduled for a debate and voted upon in the National Assembly within a reasonable time or at all.
Deputy Chief Justice Dikgang Moseneke says the primary purpose of a motion of no confidence is to ensure that the President and the National Executive are accountable to the Assembly. The minority finding was that the Constitutional Court should not get involved.
I think that the majority were correct because the Constitutional Court had to really rule on constitutionality of acts or law, and rules of parliament become part of a law governing a very important institution. It is not interfering with the role of parliament to do its work.
Parliament is also studying the judgment.
We accept that there are problems, which is why we started from last year to begin to amend the rules, to make them in line and in conformity with not just the constitution of the land, but also with the wishes of the people of the country.
Parliament's rules were found to be unconstitutional and invalid. Yulisan Jamela, SABC News, Johannesburg.
Staying with that story, this is how political parties reacted.
This is a great victory, not only for the Democratic Alliance and the other parties who joined us in this application, but for democracy in South Africa as well.
We welcome the fact that the Constitutional Court has pointed out that there are defects in the rules of Parliament.
We want to welcome the judgment. You see, it's a big victory for the opposition parties in Parliament.
The finding by the court that the rules are unconstitutional is not something new. We ourselves were aware of that. And that's why we started a process to address those defects. So there was nothing new there. And we think that Parliament must be allowed to regulate its internal affairs.
And lots of reaction coming through on Twitter, because this, of course, a very important story. And people are questioning just who has actually won this, Peter. Is it the ANC? Is it the DA? What is the Twitter sphere saying?
Well, let's find out what you've been saying at home. And these are some of the reactions that we've been getting, starting with Lucia, who says the Concourt dismisses the motion of no confidence in Zuma, but orders Parley to debate it. I'm just baffled. The joys of democracy, Lucia says. Somebody whose handle is God's Gift says, why press for a motion of no confidence when the elections are merely months away? Camille Premhid says, well done to the Constitutional Court for ruling on the no confidence motion. And Hlungwana Jabulani says the Constitutional Court is causing more squabbles in Parliament by approving the amendment of the no confidence. So, interesting reactions that we'll be getting from you. And don't forget, if there's any story that you'd like to comment on, you can send your tweets to SABC News Online. But back